It is very ironic that this year, where we are celebrating the 25th anniversary of the adoption of our Constitution, that we are debating an amendment to this Constitution that will have dire consequences for this country. Chapter 2 of the Constitution states, this Bill of Rights, and maybe it is important for the ANC to listen, this Bill of Rights is a cornerstone of democracy in South Africa. It enshrines the rights of all people in our country and affirms the democratic values of human dignity, equality, and freedom. It further states that the state must respect, protect, promote, and fulfill the rights in the Bill of Rights. Although Section 25 forms part of the Bill of Rights, the founding provisions, as stated in Chapter 1 of the Constitution, cannot be ignored, specifically the rule of law. It is within this framework that this bill must be assessed. And there are two questions. First, we have to answer, is it necessary to amend Section 25? And secondly, does it comply with the values and rights enshrined in the Constitution? Agbare adjunkspeaker, om te bepaal of 'n wysiging van artikel 25 nodig is, moet daar gekyk word na die motivering van die wysiging. Yes, the motivation for this amendment. Die motivering wat voorgehou is vir die wysiging is dat dit wat implisiet is, eksplisiet gemaak moet word, nie soos wat nou van tevore gesê is deur die agbare Motshega nie. Die werklikheid is dat hierdie motivering bloot 'n rookskerm is om regverdiging te verskaf aan 'n proses wat selfs nie eers deur almal in die ANC ondersteun word nie. Die grondwet is nie 'n stel regulasies nie. Dit bied riglyne en norme waarin handelinge en wette moet voldoen en gemeet kan word. Die wyse hoe dit in praktyk gedoen moet word hanteer deur die algemeen geldende regsvoorskrifte. Dit is waar die implisiete eksplisiet gemaak word, nie deur die grondwet te wysig nie. Wetgewing is die meganisme waardeur grondhervorming moet plaasvind. Grondhervorming moet plaasvind onder leiding van 'n regering met die nodige politieke wil en kapasiteit om dit te doen. Die grondwet en spesifiek artikel 25 is nie die struikelblok in die grondhervormingsproses nie. For example, in Section 25(4, the Constitution places a specific responsibility on the state to give effect to the nation's commitment to land reform. Section 25(5 is very clear that the state must take reasonable legislative and other measures within its available resources to foster conditions which enable citizens to gain access to land on an equitable basis. It cannot be more clear. The proposed amendment changes this specific obligation of the state and substitutes it with a vague reference to certain land to be placed under the state's custodianship. In other words, custodianship is included for the mere sake of winning the support of radical populists. The addition of custodianship also goes beyond the mandate given to the ad hoc committee by the National Assembly and can therefore not be included in this bill. To address the question of whether this bill complies with the founding provisions and values of the Constitution, we have to look at what the status of property rights is in our Constitution. A primary element of the rule of law and human rights, two of the founding provisions, is that it should include respect for property rights. This is in line with international law and specifically Article 17 of the Universal Declaration of Human Rights, to which South Africa is a party. This bill creates uncertainty regarding property rights and will have an adverse effect on investment and land improvements. The proposed amendment that states that land and any improvements on it may be expropriated with nil compensation is precisely the type of situation that will cause this uncertainty. This is not what the country needs now in the time of economic devastation during the COVID pandemic. It is therefore beyond belief that there was no socio-economic impact assessment done of this bill, and the bill itself states that there will be no financial implications. This is, to say the least, madness. We cannot allow any amendment of the Constitution that will place property rights and economic prosperity, and creating uncertainty regarding property rights goes counter to the rule of law. Our further concern is that the bill states that national legislation must set out specific circumstances where a court may determine that the amount of compensation is null. National legislation is a much lower threshold for approval, and it opens the door for arbitrary circumstances to be determined for when the compensation must be null. The Constitution as it stands provides for specific circumstances, and any legislation should be measured against that. So to answer those questions that I put at the start, there is no need to amend Section 25, and this bill falls foul of the constitutional test. Die grondwet is juist daar om die balans tussen regte te handhaaf en om die burgers van 'n land teen die vergrype van die staat te beskerm. Hierdie wetsontwerp versteur daardie balans en beskerm nie die inwoners van hierdie land nie. Dit maak ook die deur oop vir enige toekomstige wysigings aan die handves van regte. As dit nou met so gebrekkige proses aanvaar en deurgevoer word, skep dit die president vir enige verdere wegkalwing van die menseregte van die burgers van Suid-Afrika. Die DA ondersteun nie hierdie wysigingswetsontwerp nie. Dankie.